the day, and I'm going to start over again. The title of the case is People versus Roslyn Ray Keenan. The allegation is that on or about May 16th in the village of White Pigeon, she did resist and obstruct a police officer and drive with a suspended driver's license. Resisting and obstructing is a felony now. It's punishable by up to 2 years imprisonment. And driving suspended as a traffic matter, punishable by up to 93 days in jail and a fine of up to 2 points on your driving record, and it requires that your license be suspended. Someone who is identified as Roslyn Keenan is present, and she wanted to explain more about that. We'll give her a chance to do that, but prosecuting attorney David Marvin is here, and he's representing the state. So let me ask you again, are you Roslyn Ray Keenan?
I'm here as sui juris impropria persona, Roslyn Ray family of Keenan, beneficiary. Is this on record?
Yes, everything has to be on the record, so it's all being recorded.
Okay, I'm here on the special appearance, and I'm a free woman on the land. I'm here under fraud, menace, and duress. I am the private woman, Roslyn Ray.
Here we go again, another sovereign citizen who thinks courtroom laws don't apply to them. The moment she says, "I'm a free woman on the land," the judge already knows what's coming. This is how nearly every one of these encounters begins, with a fake identity and a fantasy legal system they think will protect them from reality. It's the same delusional script we've seen 100 times, like a YouTube tutorial gone wrong inside a real courtroom.
We've got another issue. This is a felony charge. The first one is. The second one is under the Motor Vehicle Code. And it requires that we have a preliminary examination, or it requires that you're entitled to a preliminary examination. We had a pre-exam conference last week, and you expressed at that time that you did not wish to have an attorney. You're here with you this morning without an attorney, and we'll address that in a moment. You've been talking with Mr. Marvin. You have an absolute right to represent yourself. I normally don't recommend it. Mr. Marvin will sit down and talk with anybody, whether they're an attorney or whether they're a layperson. So you and he have been meeting to discuss this. Mr. Marvin, is there a plea offer here?
There is. And I'll tell you about that. But I wanted to mention that this is, I believe, the third time we've sat down, and this is dragged out a bit, but only because she's not represented. And in these 3 separate meetings and adjournments, the court has allowed those, and I appreciate it. I have spent a lot of time with her and her son, who's here. He's always been here, and they're very honest. And
what's heartbreaking here is that the prosecutor actually tries to help her. He calls her good-intentioned, even offers to reduce the felony to a misdemeanor that could have been dismissed entirely. But the tragic part? People like Roslyn believe rejecting the system makes them free, when in truth, it only isolates them further. They think they're escaping the law, but they're just running from accountability.
He is offering to dismiss the felony charge and reduce it to a charge called attempted resisting and obstructing a police officer. That's a misdemeanor. It's punishable by up to 1 year in jail and a fine of up to $1,000. Do you understand that charge?
No, I don't understand the nature and the cause of the charge.
All right, Mr. Marvin, let's just do a prelim. I'm not going to tap dance with her. You may be more sympathetic about this flat earth nonsense than I am. But if I'm going to have to argue about everything from who she is to what the charge is, it'd be easier to just put on the prelim. From the affidavit of probable cause, her conduct was outrageous with a capital O. And so I'll give you one more opportunity, Ms. Keenan. Mr. Marvin is agreeing to dismiss the driving suspended charge. The record shows your license is suspended from Indiana and you don't have a valid Michigan license. That's a benefit. It won't affect your driving privileges.
Excuse me? What'd you say about the,
It's a benefit. And
no, before that about the license?
he's dismissing it. And it won't affect your driving privileges here or Michigan or Indiana if he dismisses that. So he's offering to dismiss it. And that's a benefit.
You can feel the judge's patience slipping. She's offering a deal that could keep this woman out of jail, but every sentence Roslyn says digs her deeper. The irony? The judge is showing more mercy than Roslyn's so-called freedom theories ever will. You can almost feel the judge thinking, how many times have I seen this same movie? It's a lesson in how misinformation turns courtroom mercy into chaos.
And my next question is, I know that the Constitution grants the court two types of criminal jurisdictions. One is criminal jurisdiction under common law, and the other is criminal jurisdiction under admiralty or military tribunal venue under Article 1, Section 8, Clause 17 of the Constitution. Under which of these two jurisdictions is the court intending to try me?
This is statutory jurisdiction of the law of the state of Michigan. It's not any of those things, including the wacky admiralty clause people try to invoke. This is criminal jurisdiction authorized by the state legislature here in the state of Michigan.
Thank you. Well, please let the record of the court show that the court intends to conduct a criminal action against me under a statutory jurisdiction. But that makes me wonder, I have never heard of criminal action under statutory jurisdiction, and there is no such jurisdiction established in the Constitution. And I will be able to proceed if you can show me where I can find the published rules of civil procedures under a statutory jurisdiction and where this nature, cause, and jurisdiction exists. It is crucial that I have the published rules of procedure so that I can conduct a fair defense and fair trial. Otherwise, this needs to be dismissed. And I would like it in writing, please.
Thank you. It's not civil procedure, it's criminal.
When Roslyn starts quoting the Constitution and asking if the court is under admiralty law, you can almost hear the judge's soul leave his body. This redemption through loopholes fantasy isn't new. It's an internet cult. People get sucked into YouTube videos claiming they can beat the system with magic words. But in a real courtroom, that magic vanishes fast, replaced by silence, cuffs, and confusion.
Civil procedure
All
under
right, stop.
admiralty or military
Stop.
tribunal venue.
Stop. We went through this before.
I know.
This is not civil
It's
procedure.
the Sixth Amendment grants me the right to know the jurisdiction being applied.
And I told you what it was.
And it gives you the duty.
All right, stop. If you interrupt me one more time, I'm going to find you in contempt and you're going to go to jail.
Objection, please.
All right, please.
Please.
We're going to
sir,
talk
may
about
I-
this
the
tomorrow at 3:00. I find that you're in contempt.
I
You're
do
going
not
to
wish to
jail
be held
right
in
now,
contempt,
and we
sir.
will. Well, you have been.
I'm simply
matter
trying
is
to
adjourned until
exercise
tomorrow
my
at
Sixth
3
Amendment
o'clock.
rights, please.
Well, you can think about
And
it
we can go
overnight in
forward
jail.
with this right now, please.
No, you're going to
I do
jail
not
for
wish to be in
24 hours.
contempt.
I know you don't wish to go to jail, but you certainly
I
have
will
earned it.
continue with this if you'll please let me finish.
We'll talk about it tomorrow at 3:00, and you will be more respectful to the court.
I
You
can
will speak-
provide the
You will not interrupt the
citations.
court. Your citations are meaningless.
I'm sorry.
And here's the crash. After multiple warnings, she interrupts again, and the judge finally says, "You're going to jail for 24 hours. This moment is pure justice fatigue. You can tell he didn't want to lock her up, but sometimes the only way to break delusion is with consequence. Watching her get taken away still arguing is like watching someone drown in their own words.
There we go. Go ahead and watch your foot. There we go.
That's it, then it's court over.
Yeah, we're done.
Can I say something?
Yes?
I don't think that she was trying to be in contempt of court. She was trying to exercise a right. And I think it was a misunderstanding of how to, for her to be able to pronounce that. But,
Well, I told her to stop and she didn't stop, and she doesn't know what she's doing. She needs a lawyer. And she's gonna contempt herself into 90 days if she doesn't be careful. So we'll address this tomorrow at 3 o'clock. And to whatever extent you're advising her on this stuff, you're not doing her any favors. Mr. Marvin gave her the sweetest deal where she could not have a charge on her record. And all she wants to do is argue about admiralty law.
Please have that record still, or that chart, that option still, if I talk.
And then comes the final twist. Her son. He steps up, pleading, she was just trying to exercise her rights. That's when it hits you. He's caught in it too. He doesn't realize that this isn't strength. It's confusion wearing a badge of pride. The judge's last words slice through the air. You're not doing her any favors. It's the truest line of the day, because no matter how loud they shout about freedom, belief in fake law will always end the same way, in handcuffs.